welcome back to another episode of The Leaf Pledge. Nipun, thanks for being with us again. We really appreciate your time. In the last two episodes, especially the last one, we talked about handcuffing, police remand. So, on the same note, let's get more into specific questions here. I want to ask you about the provisions regarding the proceeds of crime and why is this included?
I think that's a newly incorporated provision. This is one of those 5 to 10 problematic provisions that we were flagging. You see, proceeds of crime is something which is defined under the Prevention of Money Laundering Act, right? Or the PMLA Act, as it's called, because now it confers power on the ED to carry out what you say arrests, attachments, etc., etc. The BNSS, which is otherwise a procedural law, now talks about something called proceeds of crime. It defines a specific procedure in respect of attachment of property. Now, this is under section 107 of the BNSS. What does it do? It says that if it is discovered that there are proceeds of crime from an offense which is committed, say for instance, there's a theft, you steal something and from that money you buy something, right? Now that money, which is tainted money, is being used to convert it from tainted to white property, right?
Sure.
And you buy a or you purchase a property. Now that purchase itself will be called what you call a proceeds of crime. Before this regime existed, it was the exclusive domain of the Enforcement Directorate or ED to find out whether or not there is a proceeds of crime, and the attachment was, and the powers of attachment, etc., and whether the attachment was good, bad, or ugly, was left to specialized agencies and specialized tribunals to do it. So not every property which was purchased was, fell within the contours of proceeds of crime. What this new provision does is that it lays down an elaborate attachment proceedings, just to say that you can attach the property of a particular person if it falls within proceeds of crime, and you confer that power on an ordinary police officer.
Wow.
So in effect, PMLA provisions are now being engrafted or supplemented into regular procedure code.
So you think there's a problem with this whole attachment of property as well under this law?
Absolutely. If you look at attachment, an attachment is pursuant to a judicial function. A judge decides whether the property is to be attached or not. Even in, let's say, normal civil procedure code, it is an execution of a decree at which point of time attachment comes into picture.
And now you are saying under the new law, the police has the power to attach property.
That's right. It is the power conferred on police officers to attach or not to attach a property, and not judicial officers. And that, I think, gives unfettered, unguided, uncanalized discretion to police officers to do as they will. Because let's say a police officer is acting under an information, he receives it and says, all right, X, Y, and Z property are proceeds of crime. He brands them so, not knowing that, let's say, before that cheating was committed, that property was already purchased.
So this is in line with what you spoke in the last episode about, are we heading towards the police state then?
Well, if you confer that amount of or that degree of discretion on a police officer, it would appear that we are in fact heading towards troubled times.
But let's take a step back here. Why do you think this was done? Did the police need more power? Did the legislation think that, by overhauling these laws and providing certain new powers or conferring certain powers onto the police would sort the system out, would put things into balance, the balance that's been out of place for a while or perceived to be out of place for a while?
You see, in order to cure one evil, you have created 20 masmasos. That's what has happened, unfortunately. The solution to the problem of pendency is not giving more power to the police officers. When even Macaulay never trusted his police officers, he had carried out an extensive research in the year 1830 till the year 1860. So 30 years of research went into the IPC that was, or the CrPC that came into picture. He said that, and while he was researching, they were there in copious notes. He said that giving powers to a daroga is only going to create a lot of trouble, which is why a statement given to a police officer was never admissible in evidence.
Exactly.
Right? But now under the new regime, if there's a specific category of witnesses under 182, section 182 of the BNSS, which confers power on the police officer to record statements of a witness who comes out of his own volition to give a statement, and that statement will have a better footing than a police statement. So you will have fly-by-night witnesses in cases which are very, very difficult.
Exactly. I was going to come to the whole issue of witnesses. Let's talk about that as well.
Right. So now, because of this newly enacted provision, you are going to confer immense power on these witnesses who absolutely were nowhere to be found initially.
And you mentioned this categorically in your article as well, right?
That's right.
And I hope the audience here will go back and read those articles. But go on, please.
Yes. So under these particular new regime, initially, let's take a step back and understand what this witness Ulavo is all about. You had only two categories of witnesses. You had a police witness who used to give statements under 161, right? And that witness's statement was rightfully not admissible unless and until it was put to him and he could corroborate them during his trial, right? Merely giving a statement to the police officer was not sufficient for the purposes of conviction. Even the signature of that witness was not important. So the police officer couldn't have compelled the witness to affix his signature because Macaulay, as well as our Indian independent legislators after 1947, recognized that this would tantamount to police creating, fictitious witnesses out of thin air, right? To bring somebody or to level false allegations or false charges against that person. The problem now starts when you had another type of category of witnesses which have been brought by this act, which says that these witnesses are not your traditional police witnesses, but these are those witnesses who, in their understanding of things, have come on their own accord. They are not influenced. It uses that word. They are not influenced. They are, those witnesses. Just to tell you what the legislation uses the expression in such witnesses, it calls them voluntary witnesses.
Voluntary witness.
Voluntary witnesses. These voluntary witnesses will now come up and incident. God knows from where.
And why?
But these witnesses will come and they will say things which will not fall within the procedural safeguards of a police witness. Say, for instance, the Evidence Act, the Indian Evidence Act, the precursor to the BSA, said that, look, the evidentiary value of this is not to be looked into unless and until corroborated during trial. But for this new category of witnesses who are voluntary witnesses, there is no guidance under the new Bharatiya Sakshya Adhiniyam or the BSA. So nobody knows whether they are to be treated at the same pedestal as your regular police witnesses, or whether what they say has to be given as importance as if to a witness who is, let's say, making a 164 statement before a magistrate. Because in that case, the magistrate first satisfies herself or himself as to the capacity of the person to depose, whether that person is deposing freely, voluntarily, or whether that person is under influence or coercion in that sense. But today, this new Evidence Act gives no guidance whatsoever as to what is to be the evidentiary value of these new statements. So, assuming against myself for a second, are they to be treated at the highest pedestal as if this statement was recorded by a magistrate? Then in that case, whatever they say will be sufficient for the purpose of conviction. So are we placing so much reliance on these people, on these new category of witnesses? Can a police, in a case which is only a circumstantial case, let's say a dead body is found and there is no evidence whatsoever for 2 months, third month a new witness comes up and says, I saw it. And this new witness has come voluntarily to a police station, mind you. Not that the police found him at the instance, or he is supposed to know the people or the suspected persons or lives around the area, or was one of your punch witnesses. He's none of those witnesses. He's just one witness who happens to voluntarily come to the police and say, look, see, I have seen the offense after 2 months and please record this statement. And now will this statement given the prominence as if it were given to a court recorded statement? It's going to be so much troublesome for all of us to either defend or to prosecute.
I'm a little short of words right now, but let's take a step back.
Right.
And let's play the devil's advocate here. What about the audio-visual interference and reliance on technology for investigation? You know, it talks about it now. Is that not laudable? And what are the logistical problems with this mechanism, if any?
I think it's very laudable. To be fair, I don't want to sound very pessimistic about the system that they want to bring in place in so far as it deals with seizure of electronic evidences and other evidences, etc. But see, I will also want to be very realistic at this juncture. We who have fought trials know that forensic science laboratory examination reports, chemical analysis reports take hopeless amount of time.
And you mentioned that in a previous episode, yes.
That's right. And why does that happen is because we don't have the requisite infrastructure yet to deal with it. You see, in any case, when a charge sheet is filed, usually those chemical examination report or ballistic reports or FSL reports, I'll just call them FSL reports, are not available on record. Sometimes many critical witnesses are examined, expert witnesses are examined, and yet those reports are not there, leading for trial to be delayed. Now, with these electronic methods of search and seizure will throw open doors for defense counsels to challenge every single search and every single seizure, because every single search and seizure will have to depend on a 65B certificate. And not just a 65B certificate, an accused defense counsel, and rightly so, may want to challenge it on the ground that there was an error in transmission, right, that you did not transmit it forthwith, contrary to the guarantees which are there.
To who?
To the magistrate, to, let's say, the Ilaka magistrate who was supposed to. Did the Ilaka magistrate receive what you sent? Was it sent on a device? Where is that device? Is the device produced before the court? Where is the 65B certificate? And here there's another problem. They say you have to also mention the hash value of every device. Do you think with the current understanding that the police officers have, and I'm not talking about the SP level or the IPS officers, I'm talking about the on-ground, darogas, do you think they are blessed with the requisite understanding to properly carry out a seizure? Are they trained right now? Do they know what to seize, how to seize, and whether to transmit it? Are there designated electronic devices in place? Because we have seen with 65B, they have done a hopeless job. They don't know anything about it, even till date. And 65B has been in existence since the IT Amendment Act,
right,
of 2002.
Yeah,
so in 2002 to 2024, if you don't even understand 65B, can you do these intricate searches and seizures? I ask myself, in the face of an institution which already is lacking, you don't have those lab reports in time. So again, the concept is very good, but can you achieve it right now?
So you're saying that the implementation could be a big problem here?
Absolutely. On logistical scale, on the scale of understanding of these police officers, on the scale of defense counsels wriggling out of these things, because now the added problem is every computer output is now a primary evidence under the BSA, which is the Bharatiya Sakshya Adhiniyam, right? So under the new evidence law, there's a computer output is kept at the same pedestal as if it were a primary device.
On that note, we continuing with the few silver linings here. Any more silver linings in these three new laws?
I think one thing that I really like about the new laws is the way they treat a proclaimed offender. I think that is laudable. It has to be given to them, right? Because earlier what used to happen was that a proclaimed offender was kept at bay. As and when he is recovered or he is brought to justice, a new trial would be initiated against him. In the meantime, that proclaimed offender used to exhaust all his remedies in appeal, revisions, etc., make 482 applications. Now what has happened is, if a person runs away from the law, the trial will proceed even in his absence. But there are requisite procedural safeguards. If the court feels that this particular person's evidence has not been recorded because he was not present, then the court will direct re-examination of that witness. So it is not that proclaimed offender is is deprived or denuded of his constitutional rights, right? However, that proclaimed offender cannot file an appeal and cannot file a revision unless and until he first surrenders before the court and faces the charges formally, which I think is very good initiative. If you have chosen to run away from the law, then the law will take its own course. But if you do get back to the same stream of justice and surrender yourself, then you will be heard, which I think is good. Because what used to happen was there were multiple trials.
Right. Exactly.
Because say proclaimed offender number 2, 3 and 4 were running. One was caught in 2002, another was caught in 2010, another was caught in 2020, and the entire trial process had to be initiated for those persons, by which time the witnesses would have died, not there. The evidences would have been destroyed or consigned to record room. So all of this will cut across a lot of clutter. So I think this is one very laudable initiative that has been taken.
Coming to the last question before we conclude, why are these three laws generally against the public and how does it harm them?
These three laws bring in some very troubling provisions. Remand provisions, provisions relating to handcuffing, provisions relating to, in police cases vis-a-vis complaint cases, provisions with respect to preliminary inquiries. These are also deeply troubling, that it is going to affect every Nagarik and his or her Suraksha, as they call it, right? So the catchwords are the Nagarik and the Suraksha. Nagarik also includes an accused. A Nagarik also includes a witness.
Absolutely.
A Nagarik also includes a complainant. Now, if for a complainant, the police officer dictates as to whether his offense is to be registered or not, then where does he go because of that preliminary inquiry? For an accused, it's even worse, because at least when you were an accused, you had the guarantee of a 41A notice before you were to be arrested. Police cannot just indiscriminately arrest you.
Sure.
But because of this preliminary inquiry, today an accused does not even know why is he being summoned, whether he is being summoned as one of the witnesses or whether he is an accused. So you see, these guarantees fundamentally affect us all. And you cannot handcuff aged people because of your understanding of repeat offenders, which may not be the same as habitual offenders.
Sure.
And the hallmark, the most important thing is, hallmark of criminal law is its innate certainty. Because if the law remains vague and uncertain, it has a direct bearing on the constitutional promises and the constitutional rights of citizens.
And the safeguards. Nipun, thank you so much for your time. This has been absolutely wonderful and very insightful, right? As we wrap up this session of the leaflet, we hope to leave you with the unwavering reminder that the Constitution is not just a document. It is the cornerstone of our democracy, the protector of our freedoms and liberties, and the voice of justice. Stay informed, stay engaged, and above all, let's keep the Constitution first. Thank you for joining us.
Perfect.